Just like the street lights lit this town, like a fire in a blaze, gotta burn it down. Can't be afraid to leave this out. We got this far, don't know how. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we gonna let it out. Tonight, we gonna let it out. Tonight, we gonna let it out. Just like the sunrise, we gonna let it out. Just like a spark that's breaking out. Can't make a stop, can't turn back now. We know that there's no room for doubt. No, we can't turn back now. I see danger in your eyes. They know we'll burn down the night. Coming just like the sunrise. You know that we gonna let it out. Tonight, we gonna let it out. Tonight, we gonna let it out. Just like the sunrise, we gonna let it out.
Don't eat that up yet. Welcome in, everybody. Welcome, welcome, welcome. Sorry I'm a little late this evening, but we are here. We are here. The studio was a mess. It still feels like a mess, but we're getting it together. So we're rearranging, we're redecorating. If you're not aware, if you're new to the channel, so that's why I was a little late. We normally go live around 9:15 p.m. Eastern Standard Time, but tonight we're a little bit later. But it's Friday, you know, so I said, heck, it's Friday, right? It's Friday. I didn't think that you guys had much to do tomorrow. You know, it's only the Saturday. It's only the only day that you guys are off pretty much for the week. If you do work Monday through Friday. I don't count Sunday as a day off. I feel like that's like your day to get back into the groove of the week. So if you are new to the channel, I am Tanya or TitaniumBuilt. It's nice to meet you. We do talk true crime daily here on the channel. So if that's something you're into, don't forget to hit the subscribe button, hit the like button if you like the content. It really helps the channel and helps us get into the algorithm. So hopefully I won't have to, you know, bother you guys too much tonight with it. But hopefully, you know, hopefully. Now, I won't bother you guys too much. But welcome in, everybody. I see everybody in here. I won't say, you know, well, maybe I will. Maybe I'll say hi to everybody. Maybe I will. Hey, Ashley. Hey, Ladybug. Welcome in. Yes, a new lawyer. Hey, Stephanie. Hey, Warflare. Hey, Doodlebug. And I was actually, there's a lot of stuff coming out of Idaho. So hold on to your seats and get used to seeing me and talking about Idaho because we've got a big documents that are dropping. Hey, Mike. Hey, Petunia. Welcome in. Hey, Wizard Walt. I didn't know if it was past your bedtime. I don't know. Did I say hi to Mike? I might have. I don't even know at this point. Hello again. Hello. I'm glad that you're feeling better today, Ladybug. Hey, Lenora. Hey, Niners girl. Hey, Cole. Oh, you had a blind date? Oh, I've had nightmare blind dates. I've had the oh, yeah. They can either go really, really, really well, or they can go terribly wrong. I feel like there's never any in the middle there. Hey, Michelle. But you guys all know my story. I mean, I met my boyfriend off of Tinder, and we'll be together this month. The 28th will be our 9th year together. So, I mean, it can work. Ivy, I've missed you so much. I've been like meaning to get over to Instagram because I know that you're on Instagram and you're on or TikTok. But you look great. I wanted to tell you that I saw some of your videos on TikTok, and girl, how much are you down now without you don't even need to tell me, but you are looking great. You're looking so fabulous. People you like. Hey, Donald. Hey, DM. Hey, Crystal. It's good to see everybody in here tonight. Maybe I'll do evening lives more often, huh? Or, I know, isn't it the best? I think that song is the best. We have actually really good music for all three of for our members, our second channel, and for this channel now. I just have to I'm making a video for the pre-recorded videos. I'm in the process of doing that. Hey, PKC. I am way late, Doodlebug. I'm so late. I am so late. But I know you guys understand. Hey, Cyber Warrior. Then I had to eat, of course, Vincent was getting a little hangry. He was doing a lot today. He went to Hobby Lobby. We got stuff actually to decorate. That little flower was from over here, but I just didn't put it up tonight because I think I'm gonna wait until I get everything, I think I'm gonna wait till I get everything because I need I'm trying to find a pot, like a ceramic pot. And then I think I'll do like a members live, and you guys can help me decorate it or something. Your day's off for Sunday and Monday. Oh, look at that. It could be. Yeah, it is actually. It is my Crooked Halo. Hey, Beauty for Ashes. 43. And you've loved true crime stories for years. Oh, Cole, I've been into true crime since I was a little itty bitty thing. Zio Sandra? Did I say that right? Happy late Friday night from Ohio. Yeah, Donald. Yep, from Ohio. All day, every day. Well, as Judge Hippler would say, what, like every day and twice on Sunday? Hey, Willows, welcome in. Hey, Sunflower, that's such a cute name. I love that. It could be a ghost. Is it a ghost? I do have some on this side. Pampas grass. I need to cut it down a little bit. I'm like trying to sway over there. So we have the chair here. I'll show you guys a little bit of the setup. Oh, I can't go back any further because my treadmill's in the way. And then we just got this little table here and these little vases. All the stuff in this basket's brand new. We've got some pillows and blanket. I was going to put it on the blanket on the chair, but I love the blanket so much. I might just leave it in a different basket. That basket's going to go away. We have a tree back here in the corner. You just can't see her. We're going to get a light to put in the bottom so she illuminates a little more for you guys. It's going to look so cute when it's all done. I'm going to have a mirror over here and some art and stuff. So I'm going to show it to you guys when I'm all done with it. It's going to be so fun. It's going to be so fun. You met your husband online too? 8 years? Oh, you said husband. Uh-oh. I told Vincent I'm turning 40 in October, Vincent. I did. I said, you better. I did say right. Oh, I'm so glad. I'm really bad. I'm really bad with the names. I don't mean to be. Hey, Tempest. Oh, wait. I missed it. 179 pounds next month. First reconstructive surgery. Oh. Wow, girl. Wow. Ivy, but you did go through a lot though. You went through a lot afterwards. So you deserve them pounds that you lost. No, Nancy, I need to put her up. I don't have her up yet. I don't know where to put her. It's just, there's really no room for Nancy anymore. Just kidding, Nancy. I'll find room for you. And see, my mom met my stepdad through newspaper ads. What, the pampas grass looks like a ghost? Uh-oh. Ooh. No, I'm just like, ooh, look at that. No. Hey, Michelle. I don't know if I said hi. I might have said hi to Michelle. I don't know. I don't know who I've said hi to, who I haven't, but if I haven't said hi to you, say something in the comments. Be like, hey, you missed me. Hello. But hopefully I didn't. But welcome in, everybody. It's good to see you. Like I said, hit the like button, hit the subscribe button, and we're going to get on with tonight's live. And we'll be talking while we do. There she is. There's Mary Beth. There's Mary Beth. Mary Beth was probably like, Tanya, what are you doing up this late? But you get to sleep in tomorrow. And I'm just still laughing in my head about Walt's blind date. If I could be a fly on that wall, You gotta go. There you go. Hey, KCG. Hey, Pam. That's the way to do it. Yep. Vincent's my sugar daddy. I don't know if he knows that, but he is. He definitely is. I'm like, he definitely is. It was horrible. I'll tell you. Okay, so speaking of blind dates and being blind, I went on a blind date one time, and it was so bad. I told the guy, he didn't even know until I said something, which was, first off, that was stupid. But I always felt like I had to tell people about my vision, about me losing my eye. It was just something I did because I was young at the time. I was like 29, I think, when I went on this date, 29. It was right before I met Vincent, so it was probably 29. And as soon as I told this guy, who was ex-military, that I lost my eye, first thing he said to me, and don't feel bad for me. Don't feel bad. I felt bad for myself enough about this. He was like, I can't even look at you anymore, or something like that. And I was like, what? Like, I literally was like, I was shook. I was shook that somebody had the nerve. Like, I was like, well, at least you're honest, I guess, right? So I don't even think that, I think I like left. I think that I ended up like taking an Uber and just like leaving. Like, you know what I mean? Just like I left. Like, I was just like, But then it was like I met Vincent right after that. It was like it was meant to be. You know what I mean? So don't feel bad for me. It was just one of those things. It was just like, but I was thinking in my head, I remember thinking later on going, he's military. And he said he was, overseas. Like, surely he had seen worse than a girl with a prosthetic. Right. I mean, it wasn't like I was just like hanging out with it, like out of my face. Like, I should have. Now I know. That will never happen again, because Vincent puts my eye in for me and helps me. So, like, look at that. Well, oh, blessed. Okay. Speaking of me being blessed, I'm gonna start talking about the case, because I'll be like, I'll talk about it all night. But yeah, I definitely am. There's Aries. Where's Princess? And I said, did I see a comment? No, I didn't. Doodlebug. Okay. I was just thinking, like, hey, I already said, hey, Pam. Let me see. Go back up. Wait, did I really miss it? Anne Rules. I didn't read her books. But I read all of the, was it Fear Street? I'm trying to like go back and see it. I don't see it. Is everything okay with her? I hope. Okay, Doodlebug. I'm almost like all the way to the top, I feel like. Okay. Okay, if it's not too much, try to write it again, because I can't find it anywhere. I was all the way near the top. I was like all the way up there, like up where, like, I don't even know what it was saying, but yeah. She has a double ear infection. Oh, I hope she feels better if she's listening in. Everybody's getting sick. I don't like that. So this new document came out. She gone to bed, double ear infection. Oh man. Well, I hope you feel better. She's listening to this on the replay. Hey, KJ. So this came out. We had a couple documents come out the other day. And we covered Luigi last night because I remember thinking like these aren't like they were like I didn't think at the time that they were like groundbreaking documents or anything, of the sort. And I should have read a little like slower maybe, and then I would have comprehended what was like happening in this document. But I was thinking that they were bringing this person that we're going to talk about tonight. I thought they were just bringing her on to be an expert witness again. So that's what my brain went to. So, but that's not what it is. So it is. And I don't have these downloaded, so they're not color coordinated, but it's an order granting motion for pro hack vice. I think that's how you say it. So, and what that means is like for this occasion only. So it says the court having considered the motion for pro hack vice admission and being fully advised in the premises good cause appearing now, therefore, it is hereby ordered that Becca Barlow, we all know that name. We've heard that name before. Be admitted pro hack vice in this case, and that Ann Taylor serve as local counsel, whose attendance shall be required in all court proceedings in which Becca Barlow appears, unless specifically excused by the court. So I thought when I read that they were just bringing her in for this one time only, like one hearing. I was thinking one hearing. And it was for an expert witness again, but it's not. It is hereby ordered that co-counsel Lisa G. Massif will remain in her position as trial counsel. Co-counsel J. Logston will remain as counseling counsel, but will not participate as trial counsel, meaning he'll be like consulting counsel. So like if if Anne needs a question answered and she can't get an answer with anybody within her office or something, she can go and ask Jay Logston, but he will no longer be participating in the trial. Our good buddy Jay tapped out. He tapped out early. I don't know why. He's not retiring. I mean, look, he's my age, a little bit older than me, maybe. But yeah, so that's part of the news. Oh, hey, Karina. Well, yeah, Michelle. Yeah. Becca is a big gun. If I had to, I was reading up on her. We're going to read a little bit about her tonight. If I had to have my choice in counsel from what I've seen from Jay and what I've read from Becca would be my choice. She's got a lot. She's got a lot backing her. She's been in the game a while. She's got a ton of training and places and classes that she's taken and different training that she's taken. She's going to be pretty good for them, which is good. I mean, give them as many as you want. I thought he was going to have just like all four sitting there, but no, apparently just the three will be sitting there. And they have her right here, Becca Barlow, attorney at law. Names on there, names on the paperwork already. So they also came out with the transcript for the January 23rd hearing that we didn't get to hear. It was a closed hearing, and they were going to give us the transcripts after the defense and the prosecution had 14 days to go through and redact anything that they wanted redacted out of it. And then Judge Hippler was releasing it. Well, he did. And I was going to go over that tonight. And then I looked at the document when I couldn't even get to my desk. I was like, I had my wireless thing, like my wireless keyboard, like back all the way back, like here sitting, like trying to look at the screen. But it's 175 pages. So what I'm going to try to do is I'm going to try to get someone to read it with me. That way it's more like, it's just like more entertaining, like to have two different people reading, because there's like different people, like Ann Taylor, and then I don't know, Bill Thompson, like just different people. So I asked, I commented on Jays for Justice because I know she follows this case. And I asked her if she had seen the transcript yet. So we'll see. I asked her if she wanted to read them out with me, because I was like, I don't want to read these by myself. But if I have to, if I do, I mean, if I have to, I will. Maybe I'll put like a post on the community tab, or if one of you guys want to come up and help me read, it's a lot. And so we'll be starting that tomorrow. And it is redacted, but it's still 175 pages. Now, I guess I'll show you. Like, I guess it is kind of like big. So it probably wouldn't take but maybe 2 lives to get through it. But no one's went through it all yet, as far as I know. But we do have a new lawyer in town. So it says, shakeup hits Bryan Kohberger's defense after judge rules to keep DNA for Idaho murder trial. And it was like perfect timing, And then here's the full interview with Steve. We'll play this also, because I didn't get to hear the full interview. I played you guys like half of it or something. So the defense team, this is going to be, let's see. I thought it like told me up there how long it takes, but the defense team for Moscow College student homicide suspect Bryan Kohberger is undergoing a shakeup. I wonder how he feels about this. I mean, I'm sure he probably feels okay about it, and probably told him this is the best thing for him. And, after he probably cried himself to sleep when nothing got suppressed last week. I would. Jay Logston, North Idaho State Public Defender and co-counsel for Kohberger's defense, will be replaced for his capital murder trial, a Thursday court order said. Taking Logston's spot is a Northern California attorney who specializes in DNA and previously testified as a paid consultant for the defense in this case. And that's why she's coming in under that pro hack vice, because she's not, I think it's because she's not like licensed in Idaho. She's licensed in California. So I think that's why. And it says, Bricka Barlow, formerly of the San Francisco Public Defender's Office, joins the trio of lawyers defending Kohberger since 2013. She has run a private law office with the focus on cases that involve forensic DNA evidence, according to her website. And I have her website up here too. No reason was listed for the attorney substitution in the high-profile case. Patrick Orr, spokesperson for the Idaho State Public Defender's Office, where Logston is employed, declined to comment to the Idaho Statesman on the move, citing the standing gag order in the Kohberger case. I feel like if it was something small, like, or like, he got another job, he was like moving, I don't know. I feel like you could say that. Why are they taking him off? Kohberger, 30, is accused of a fatal stabbing of 4 University of Idaho students in November 2022. He is charged with 4 counts of first-degree murder and count of felony burglary. The case is scheduled to go to trial this summer, and the state intends to seek the death penalty for Kohberger if a jury finds him guilty of the murders. The 4 victims were Madison Mogan, 21, of Coeur d'Alene, Kaylee Concalves, 21, of Rathdrum, Xander Kernodle, 20, of Post Falls, and Nathan Chapin, 20, of Mount Vernon, Washington. The 3 women lived at an off-campus home in Moscow, where they were found stabbed to death, and Chapin was Kernodle's boyfriend and stayed over for the night. There's Jay there. If you are not sure who's Jay, that's Jay. A leather sheath for a fixed blade knife was located next to the body of one of the victims, according to the probable cause affidavit. Investigators discovered DNA on the sheath, which, after analysis, later came back as a statistical match to Kohberger, police and prosecutors alleged. Logston, who has been Kohberger's number 2 public defender for about 2 years, will be retained as a consulting attorney. Lead defense attorney Ann Taylor wrote in a request to add Barlow to Kohberger's legal team, which also includes attorney Elisa Massif. Logston will not participate as trial counsel, Taylor said. So if she can say that, why can't they say why? I don't know. Barlow was a defense witness at an August 2023 court hearing over the state's effort to limit some records related to the FBI's use in the case of an advanced DNA technique called investigative genetic genealogy, or IgG, which first landed on Kohberger as the suspect. The prosecution objected to Barlow's testimony as improper and a veiled attempt to include the legal conclusions of an attorney not affiliated with the case. Well, she fixed that, didn't she? She's affiliated now. The prior judge allowed the defense to call her to the stand and later awarded the DNA records to the defense. Barlow also was present last month in the courtroom for hearings over the defense's push to suppress a variety of evidence, including DNA. Ada County Judge Stephen Hippler, now overseeing the closely watched case, earlier this week denied each of those requests to exclude any of the items seized from Kohberger through search warrants and during his arrest in late December 2022. So all of her, she wanted the AT&T, the warrant on his person, the warrant from the Pennsylvania house, the warrant on his apartment, the warrant on his car, the DNA. She wanted all that suppressed. And Judge Hippler was like, let me give you a decision. We waited up 2 weeks almost, and then we got our decision. Denied, all of them denied. Now I wonder if Ann Taylor's like, yeah, I'm glad I brought Barlow on the case. Because she was there last month for the hearings. So it says, time to pivot and focus on trial. The timing of the attorney swap about 5 months ahead of trial doesn't come as a shock. Josh Ritter, a criminal defense attorney in Los Angeles and host of true crime podcast Courtroom Confidential, told The Statesman. Instead, the action represented the defense fine-tuning who will be the in-court attorneys. They getting their A players up there, pretty much A game. They got to get their A players. And this is a big case. But wow, you know what? You notice actually, Jay Logston, he spoke. We're going to have to go back through the old hearings. He spoke in the first couple of hearings, a lot, the whole time. And then all of a sudden, he didn't talk anymore. Remember? He was over kind of towards the side. One hearing, he was behind everybody, on his phone or computer. He was on something. He was just what he was kind of just ignoring what was going on. I don't know what life was going on around him. He checked out. So I remember seeing him not being close to the table as much. Yeah, Donald, I don't think he's going to like those changes. Yeah, death penalty experience. Yeah. It's wow, It says, to me, it's a swift battle strategy change. Ritter said by phone, they realize this front of what? They realize this. Sometimes they don't write these articles right. It's not my reading. It's the articles. They realize this front to get the DNA kicked out from a legal standpoint and now been foreclosed. And now it's time to pivot and focus on trial. Okay, that was bad writing. And in doing so, they needed to reorganize their trial team. Barlow's established legal practice area of DNA and IgG makes her a logical choice for Kohberger's defense team, Boise criminal defense attorney Edwina L. Cox added. The heart of the prosecution is also the anesthesis of the case, she said by phone. And that's how do you explain that his DNA was there on this knife sheath, she said in a phone interview with The Statesman. So absolutely bringing in someone to defend against this critical piece of evidence makes sense. The prosecution, led by Latah County Prosecutor Bill Thompson, also in the midst of subbing out a member of its team in the Kohberger case. Late last year, Thompson filed a request which Hippler granted to replace prosecutor Ingrid Beatty, She leaving too? A special assistant attorney general assigned to the case. I didn't know she left. In January, Beatty left the Idaho Attorney General's office. Okay, well, that's why. To join the Cannon County's prosecutor's office, according to her LinkedIn profile. Well, she was leaving the office. Okay. I was like, because that's the one with the brown hair, right? Over here, this lady in the middle. Or that's her, I thought. Or she knew. Now I'm have to look. Are these two women different look? I mean, now I'm like confused because this lady in this picture that's pictured here has been the same attorney, I think, with them. And see how Jay's off to the side over here? You can even see it in the picture right here. Like he's just like off to the side on his computer. Like he's just doing his own thing. He checked out. He's gone. Okay, where were we? I don't even know where we're at. Okay, I just don't want to like miss anything. It says in January, Beatty left the Idaho Attorney's office. So yeah. Okay, Beatty and Deputy Attorney General Jeff Nye, chief of the office criminal law division, were assigned in April 2023 to assist Thompson and his senior deputy attorney, Ashley Jennings, with the case. Or that's not Ashley Jennings, though. Nye remains a member of the team prosecuting Kohberger, but Beatty's replacement from the attorney general's office has yet to be named in court filings. Okay, so they haven't named the person yet. I gotcha. Because I'm like, am I losing it? The defense edition of a lawyer well-versed in DNA evidence is likely of great consequence, Ritter said. He compared it to when attorney Barry Schreck, a DNA expert, joined the high-powered defense team for O.J. Simpson for his 1995 double murder trial in Los Angeles. We are in 2025. Let's not talk about OJ no more in his stupid case that he got off on. I mean, like, come on now. We all know it. We all know it. We all know it. I mean, even the people that were cheering after that verdict was read, they all knew it. DNA evidence was still in its infancy at the time, and Schreck played a critical role in Simpson's acquittal. Kohberger's attorneys have their work cut out for them now that Hippler ruled that the knife sheath DNA said to be the defendant's will be included at trial, he said. But with her inclusion, Barlow can be expected to lead arguments about the case's key piece of evidence to convince jurors that the crime scene DNA may not be what it appears, as Simpson defense succeeded in doing, Ritter said. Maybe we should watch the O.J. Simpson trial. They have a hell of a job ahead of them because a lot of things have changed over the last 30 years, he said. Kohberger is due in court for a hearing before Hippler on April 9th, so everybody clear your schedule. Jury selection is scheduled to begin July 30th. Sorry, I couldn't get that out. So, yeah, this is short, her autobiography. Why does she have a picture of her when she was back from when she was like 20s? Look, see that picture? This one. She don't look like that no more. Becca Barlow received a Bachelor of Science degree from the University of California, Berkeley in genetics. She pursued her scientific and academic interests and obtained a Master's of Science degree from Cornell University in the fields of genetic and developmental biology, with minors in plant molecule biology and cellular biology. Ms. Barlow's studies focused on the molecular mechanisms for controlling the expression of genes during development in plants and yeast. Ms. Barlow moved on to the law and obtained her GD from the University of San Francisco School of Law, graduating magna cum laude. After serving as a research attorney for the criminal division of the San Francisco Superior Court, Ms. Barlow opened her private criminal law practice. From the beginning, she focused on DNA cases. During her time in private practice, Ms. Barlow acted as an attorney/consultant on over 100 DNA cases at all stages of the proceedings, from trial to post-conviction in federal and state courts. In 1998, wow, that was a long time ago, Ms. Barlow, along with lead counsel Michael Burke, conducted the first successful challenge in the United States to the admissibility of the STR evidence in the case of People versus Spoken. Ms. Barlow was DNA counsel in a capital case in 2000 that resulted in a life verdict. Thank you, Mary Beth, for gifting out 5 memberships. Thank you. Welcome in, everybody. I always like looking and seeing if it's people that don't like me. I don't think there's that many. I don't think there's that many that don't like me. I'm a pretty likable person, but I always like to look. And yeah, I am a pretty likable person, so. It says here that Ms. Barlow was also co-counsel in a capital post-conviction case in Dennis Lawley, in which she was responsible for the handling of toll mark evidence. This evidence was the only physical evidence linking Lawley to the homicide. Later, the evidence that the gun found in Lawley's possession was the murder weapon was disproven by the discovery of the actual gun found buried in a field over 20 years after the crime. Well, that has nothing to do with her. That had absolutely nothing to do with her. They found it later on. They found the actual gun. All right. In 2004, Ms. Barlow became the DNA attorney for the San Francisco Public Defender's Office, where she acted as an in-house expert consulting with attorneys in cases involving DNA evidence and acting as co-counsel preliminary on I can't even say my words tonight, on homicide and serious felony cases. In 2013, Ms. Barlow returned to private practice. She now specializes in case-solving forensic DNA evidence throughout the United States. Her experience covers all types of cases, including SDR-based DNA testing, mitochondrial DNA testing, and YSTR-based testing. So she knows her DNA. She knows her DNA. Well, I'm pretty sure that this judge has overseen murder cases before. I'm pretty sure he probably sees them way more than Judge. You know what I mean? Hey, Elizabeth. If you guys don't mind, could you hit that like button for me? I know that I've asked you a couple times, but it really does help get us out into the algorithm, and that's where we want to be. Yeah, we're about to our next number. Is it 19,000? I think. Yeah, we're almost there. We're almost getting there. I'm excited about it. Okay, which one should we play? Let's play this one. Okay, so these are important updates. Important updates. So that's what we're working on tonight. If you're just now joining us and you're like, what's going on in the Idaho 4 case, Tanya? We just went over where Judge Hippler, not Judge Hippler, Jay Logston is going to be taken off of the case, and they are going to have Bicca Barlow come on as acting counsel for this case only with Ann Taylor. He will be there to consult, like probably at the office, but he will not be at the trial. He will not be consulting trial lawyer or any of that. So now we're going to watch Anjanette Levy, and she's going to probably break that down a little more. Maybe not. I don't know. This came out actually 5 hours ago, so we'll see how good they are. I got through about half of it. She does say something in here that made me go, what? She says, okay, so you know that they were saying that DM, which is so okay. They were saying, Bryan's attorneys were saying that DM was like drunk when she was giving her like, or she was drunk the night that she saw, Bryan Kohberger, and when she went to give her, witness like testimony, it can't be used in court. It shouldn't be admissible because maybe she was drinking and she really didn't know what she was seeing, this, that, and the other. Well, Anjanette Levy says that DM, Dylan Mortensen, said that when she saw Bryan Kohberger, he had what appeared to be like a vacuum sealed container or like bag with him. Like he was holding it. And it's about the 7-minute mark, 6-minute mark, 5-minute mark. I can't remember for sure, but we'll hear it again and I'll pause it whenever I hear that and we'll go back because I don't remember hearing that at all, ever. Not even a little bit, not ever once. Let me know if you guys have heard that. And I'll go ahead and I'll play this. But yeah, it was like kind of like, what? So
Kohberger's attorneys had hoped to get evidence thrown out in his quadruple murder.
Like vacuum like objects, is that what she said? Yeah. And so what does that even mean? Like a vacuum bag? Because I was thinking like a vacuum bag or like the canister. Although he left the canister at his house, the one there, he left that when he left, but.
Case. Instead, they suffer a crushing defeat months ahead of trial. I have the judge's orders and the new details about the case. The judge
was it in the where am I missing it? Where's the new info? Is it in the transcripts? Because I haven't went through the transcripts yet. I ain't gonna lie to you. I couldn't move them here to Vincent put a new light in and I think he was about to die doing it. Poor guy.
Included. Welcome to Crime Fix. I'm Anjanette Levy. Bryan Kohberger's lawyers spent 2 days questioning witnesses and arguing in front of the judge to get evidence in his case suppressed. That means thrown out. Kohberger argued the investigative genetic gene.
See, I bet it's because I didn't read through all those documents. I read like halfway through them. Remember, those were like the only ones we didn't read all the way stinking through like we normally do.
Genealogy used to identify him as a suspect violated his rights, along with the search of his parents' trash in Pennsylvania. He also wanted the searches of his many, many email accounts, his Apple and Google accounts, his cell phone and Amazon accounts thrown out, along with anything he said during his arrest. But Judge Stephen Hippler said it all.
Along with anything that he said during his arrest. So it is true. He did say stuff. It came out that he said, who else was arrested? Just like BTK. I don't know if he was trying to be like him or what. Or if he thought maybe his dad was arrested or something. And then he said he was going to be exonerated. Are they trying to get those thrown out? Perhaps, maybe. Thank you, KCG. That's so nice of you for gifting a membership. Thank you. Girl Crowd got it. Oh, I know. I need all the info. Hey, lunch lady. I like that name. Okay.
All can come in, and that police did not violate Kohberger's rights. Judge Hippler also denied Kohberger's.
Look at those sleeves. Every time. I'm sorry. I'm going to say it every time. Who dressed him? And why didn't you tell him to pull down his jacket?
Request for a Franks hearing, where Kohberger's lawyer.
Okay, see right here. Jay's in the front seat. He's driving, right? With Ann. He's in the passenger seat. She's driving, but
wanted to show that law enforcement either lied to obtain search warrants or were reckless in giving false information. In the judge's orders, Hippler released new details about the case that we didn't know previously. Kohberger faces the possibility of the death penalty if he's convicted of murdering University of Idaho students Maddie Mogen, Kaylee Gonsalves, Ethan Chapin, and Xana Kernodle in a house in Moscow, Idaho in November of 2022. Kohberger maintains he didn't commit the murders. Let's start with the Franks hearing. That's where Kohberger's lawyers wanted to question officers about their belief that they provided false information in affidavits to get search warrants. Judge Hippler discussed the standard at a hearing last month.
I mean, I guess from a Frank's perspective, though, the question is was there a material intentional misstatement or a reckless misstatement?
Kohberger claims 17 affidavits for search warrants contained false statements or exculpatory information. That's information that could exonerate Bryan Kohberger. Kohberger's lawyers pointed to statements police used from a surviving roommate identified as DM in affidavits.
They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream. There are 2 references to not remembering. A couple of days later, there's the 3rd interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399. At page 406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements.
Crying in the bathroom? That's new. Hold up. Crying in the bathroom? No, what? The PCA is over in the bedroom. I was looking at it earlier today. I mean, I know every word of it. I shouldn't, she's never said that. She's never said somebody was crying in the bathroom. She said what she thought was Gonzalez crying, or Coronado, I'm sorry. Xana. Now I'm beginning to wonder, but I'm going to keep still giving her the benefit of the doubt because shock and trauma is a freaking crazy ride, and I've been there for it. But oh man, I'm gonna go back.
So if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom.
Look right here, actually. Hold on. Just pull it up right here. I'm like, this is weird. Dang, Bryan, why do you have to have so many dang freaking documents, buddy? Sorry. Okay. I'm trying to find where it was like. Okay, right here. DM stated she opened the door a second time when she heard what she thought was crying coming from Coronato's room. I mean, that's not the stairs.
These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation.
A Frank's hearing would be required if false or omitted information was necessary to a finding of probable cause. Judge Hippler found that neither occurred and denied the request for the Frank's hearing. Hippler wrote, while defendant's challenge may be fodder for cross-examination, it is not the proper subject of a Frank's motion. Defendant's own proffer establishes that DM's accounts were remarkably consistent throughout her multiple interviews with law enforcement. And further, the probable cause affidavits are very consistent with her accounts. Second, DM's interview statements that her memories were fuzzy and dreamlike and may have been affected by being tired or under the influence of alcohol do not call into question her reliability to the extent Frank's would require disclosure. Finally, DM's failure to recognize the photo of defendant is of no consequence given that the intruder she saw was masked. Judge Hippler wrote that DM's description of the man she saw in the house was remarkably consistent. You heard that. a white male with a lean body type, slightly taller than her, about 5'10", with a mask covering his nose, mouth, and forehead. At the last hearing, Kohberger's lawyers said police should have written in their affidavit that DM couldn't identify Bryan Kohberger when she was shown his mugshot after his arrest. But Hippler said that didn't matter and it wasn't exculpatory. Hippler quoted DM as saying in an interview, "I have no clue. From what I remember, I just remember seeing this figure that was more of like the skinnier tone build and some mask on. I don't know if it was covering his mouth, his nose, or below his mouth and nose. I just remember he was white, but I didn't know
What? Now we're changing the mask covering?
how he was white. I just knew he was. And I knew he looked at me because of the bushy eyebrows." I want to tell you about a free app I've tried. It's called Upside, and you can get real cash
It's like right after this, I think. Because I remember this commercial.
extra 25 cents back on your first gallon of gas. DM saying the man looked at me is terrifying. Another interesting
So that means, that means he saw her. So why didn't he unalive her? Maybe he was too tired. 4 people, one of them being a male that's just as big, if not bigger than you. Stronger than, definitely I would say stronger. I would definitely put Ethan stronger than Bryan Kohberger. He played sports. He was athletic. He was younger. He didn't do rugs. So his body wasn't torn down, from that, like previous rug use. But man,
interesting piece of information we hadn't heard until Hippler's order. DM said the man carried a vacuum type object as he walked toward the sliding glass door.
like what the heck is a vacuum type object? Like, what is a vacuum type object? Well, after we watch this, I won't have to go back through them. I usually read them all, but I didn't read those. I've been losing people when I read documents, it seems like. So I haven't been reading a whole lot of documents. I've just been doing giving you the gist normally, because I usually read through them, but I didn't have a chance to read through those ones. Wow.
Is this something the killer took from the home?
Yeah, like what the heck is a vacuum sealed or vacuum? What I'm gonna look that up. That's just weird.
Order. DM said the man carried a vacuum type object as he walked toward
Vacuum type. To me, that sounds like a vacuum cleaner, like a vacuum, like a canister or a vacuum type object. Let me read. What did she say?
DM said the man carried a vacuum type object.
What if it's like one of them? Oh my god! What if it's like a small vacuum cleaner? What if it's like a handheld vacuum? I don't know why he would be carrying a handheld vacuum, but just one of them real small ones. And he did leave a vacuum canister at his house. And the police have it. I can't think of what else would be a vacuum type object. A vacuum type object. I know I've said, like, if you're playing a drinking game, you're probably really drunk. But why do they give us information like that? And it's just a little bit and we're all like, what? What's everyone else been saying? Has anyone else went over this? Like, what are other creators saying?
As he walked toward the sliding glass.
What are you guys saying? What do you guys think? Could you imagine if he had a robot vacuum cleaner with him or something? It's not funny, but it is. Because he's OCD.
Glass door. Is this something the killer took from the home? We don't know. Hippler also denied the request for a Franks hearing based on Kohberger's claim that police didn't disclose in affidavits that the victim's blood and DNA had not been found in Kohberger's apartment or car.
But what would be your reason for bringing it? Really? You know what I mean? Like if it was a vacuum, like if it was like a handheld vacuum, like what would be, you know, like what are you going to vacuum up? BLOOD? No. It's not like, you know, you're like using a gun and you're going to like vacuum up the shell casings or something. I don't know. You know what I mean? Like they need to tell us what that is.
Kohberger's attorney, Ann Taylor, had made other arguments for a Franks hearing when it came to information she said the police did not include in the affidavits.
You know, the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like DNA in blood on the wall from Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections.
Could it be a vacuum sealed bag? Like, you know, I have them in my closet. You know, the ones that you have the pump, you have to pump it and it vacuum seals everything. Like it squishes it down. Now, I don't know if DM would know by looking at that bag that that's what it is. But if she saw the little, like, you know, leather on there, like a lever that, you know, puts the air in, takes the air out, or holds the air in, you know, and then takes it out, maybe. Like a vacuum sealed bag. Because then he could be using that to put the clothes in. Like maybe he was getting it, like maybe it was, I don't know. But maybe it was folded and he was unfolding it as he was going to walk out the door or go get the knife sheath.
There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection.
Part of Taylor's argument had to do with the investigative genetic genealogy and the lack of connection between Kohberger and the victims. But Judge Hippler said Taylor's argument didn't meet the bar. Now to Kohberger's request to suppress his arrest at his parents' home in Pennsylvania. Kohberger had argued that police violated his rights when they broke down the door to his parents' home in the early morning hours of November 30th of 2022. At a hearing last month, Detective Payne talked about where they found Kohberger's car during the arrest.
Where was Mr. Kohberger's car parked at the time of his arrest?
It was in the garage.
Was it later seized pursuant to a search warrant from the
I wonder if he parked there before.
The police planned to arrest.
Like, in the garage, right? It's kind of weird if you think about it. Like, wouldn't his mom and dad park in the garage? Like, it's their house, you know what I mean? Like, would they be used to parking in the garage? If there's room to park a car in the garage.
Arrest Kohberger by knocking and announcing, but switched to a no-knock warrant. Judge Hippler's order denying Kohberger's motion explains why. Hippler wrote, at 12:33 a.m., snipers observed a kitchen light turn on and saw a taller, young white male wearing a black hoodie standing near the glass sliding door leading out to the deck. At 12:40 a.m., the same person was seen again. This time, officers were able to positively identify the person as defendant. At 12:55 a.m., the light turned on in the garage, where defendant's vehicle was believed to be parked. At 1:03 a.m., lights flashed in the garage, as if the vehicle was being locked or unlocked by a key fob. At 1:09 a.m., defendant was seen in the kitchen of the home, this time wearing rubber gloves and handling a plastic baggie. Based on these observations, law enforcement believed defendant was potentially destroying evidence from the vehicle that was related to the homicides. Law enforcement was also aware that defendant possessed a Glock handgun, prompting a concern over officer safety due to the defendant's heightened mental state of awareness or threat level of police possibly tracking him. These are called exigent circumstances, and that allows law enforcement to arrest someone using a no-knock warrant. Hippler went on to write, the executing officer's new defendant, based on compelling evidence, was believed to have orchestrated an unprovoked and exceptionally brutal quadruple homicide with a knife. They had information he was in possession of a Glock handgun. They knew he was in the residence, awake, potentially aware of law enforcement's presence, and potentially destroying evidence or perhaps retrieving his gun or a weapon from the vehicle. His vehicle was in the garage nearby, thus giving him a means of quick escape. Judge Hippler wrote that Bryan Kohberger was taken into custody in a bedroom, and a .22 caliber Glock handgun was found in his bedroom. Kohberger also wanted.
See, I thought we knew that before. I thought we heard that he was arrested in the bedroom. He had on like Under Armour long sleeve shirt, Under Armour like sweatshirt, Under Armour shorts, boxers, socks, like black socks and like tennis shoes. Like he was like I don't know if he was laying in bed when he was caught or if he was standing up, but either way, he was ready to run at any time. He had the shoes and everything on. That early in the morning, he had the shoes and ready. He was ready.
Wanted any statements he made to law enforcement suppressed, arguing they were the fruit of the poisonous tree from the arrest that he claimed violated his rights. His attorneys acknowledged officers had read Kohberger's rights twice.
Were you present when Detective Gilbert Mirandized Mr. Kohberger at the station?
Detective Gilbertson?
Gilbertson, sorry, yes.
Yes, ma'am.
And that took place after Mr. Kohberger was first seized in his home, right?
Correct.
That also took place after he was transported in the back of a police car to the station, right? You noted in your report that Detective Gilbertson had a recorder in his pocket at the time of the interview.
I believe so.
Were there any recordings that took place at the Kohberger home when entry was made into the house?
I do not know.
Judge Hippler wrote that Kohberger told officers that he had that handgun and engaged in small talk with them after his arrest. He said that officers asked them what was going on with his arrest as they drove him to the police barracks. Hippler wrote, the state does not dispute defendant was in custody when first detained. However, there is no evidence before the court that defendant was interrogated at any point from his arrest to the time he was formally interviewed by Detective Payne, at which point he was Mirandized. The sole evidence is that defendant engaged in small talk with officers, with the only exception being when he briefly asked about his arrest and was told that investigators were going to speak to him at the station about the situation. Voluntary or spontaneous statements or questions unprompted by interrogation fall outside the scope of Miranda. Next, Hippler's order denying Kohberger's request to suppress the DNA evidence in the case because of the genetic genealogy work used to identify Bryan Kohberger as a suspect. A male DNA profile was found on a K-bar knife sheath found next to Maddie Mogen's body. The crime lab named that DNA profile Q1.1. Hippler wrote, the Idaho State Police delivered Q1.1 to Othram on November 22, 2022. Othram developed a SNP profile from Q1.1 and searched family tree DNA in GEDmatch Pro. This work revealed 4 brothers of interest, all of whom were low matches to Q1.1. A footnote states these brothers did not share defendant's last name. So that was an interesting bit of information right there.
So yeah, would that be like his cousins or something? I don't know. They're like brothers that were related to Bryan, were the ones that like, that's who they're distant relatives or something. And that's who they matched to Bryan, like, you know, to get to Bryan.
In the investigation, Othram came up with 4 brothers determined to be low matches. Then the FBI got involved. And this is where
second, third cousins.
Kohberger argued his rights were violated. Kohberger said the FBI ran the profile through MyHeritage and GEDmatch, 2 databases that do not allow law enforcement to access their databases. Only Family Tree DNA and GEDmatch Pro allow law enforcement access. Kohberger argued that agents accessing MyHeritage and GEDmatch violated a DOJ policy, but Hippler said the policy was simply guidance and didn't place any legal restrictions on law enforcement. Kohberger had also argued that law enforcement needed a warrant for the work.
Your Honor, our position is that the court should suppress
Me
the
too.
IGG identification and everything that flows from that. This is supported by Fourth Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required, none was given, and so this must be suppressed.
Hippler disagreed, writing, "The state denies that the testing of the DNA from the sheath was a search, pointing out the DNA was lawfully seized evidence from the scene of the crime. The state further contends defendant has not demonstrated he had a reasonable expectation of privacy in this DNA because he had abandoned it and or because he has not shown the existence of a reasonable privacy interest society is willing to recognize." Judge Hippler said he found no violation of Bryan Kohberger's Fourth Amendment rights. I want to bring in Philip Dubé. He's kind of been on this journey with me through these motions to suppress since the very beginning, and he's
Man,
been
his
right
smile. Man, that's like a light bulb, his smile.
on all of these
Oh, but he always has the prettiest flowers behind him.
issues. He's court-appointed counsel. He is based in Los Angeles. So, Philip, with the investigative genetic genealogy motion to suppress, I mean, all of these motions to suppress were denied, but you believed that this would be denied because you didn't believe that Bryan Kohberger had a privacy right to other people's DNA uploaded to a public database. And the judge found there was no Fourth Amendment violation here.
That's correct. He had no standing, as we call it in the law. And the U.S. Supreme Court revolutionized the standing rule back in the 60s in a case called Katz, K-A-T-Z versus United States. And what a defendant has to show just preliminarily to suppress a search warrant or a search is that he or she has a subjective expectation of privacy, and objectively it has to be the type of interest in privacy that society is willing to embrace. The court found no, he had neither. He didn't have a subjective or objective expectation of privacy. Instead, everybody else maybe who was in the database that uploaded their DNA did. And the right to suppress evidence is not only personal to a defendant, but the item that you're seeking to suppress has to be personal to that defendant as well. So, for example, had the family of Bryan Kohberger been charged, that might be a different conversation because his heirs' DNA was uploaded into these private data banks, and they have their own privacy and contractual interests in the specimens that were uploaded. But as to Bryan, the judge got it right.
Yeah, and I thought there was some interesting stuff in here as well. Like Ann Taylor was arguing that the DNA on the sheath, that single source male profile that they're now calling Q1.1, that they needed a warrant, that the cops needed a warrant when that was sent to the crime lab to even like test that DNA or search that DNA. I was like, that sounds bizarro to me, because that seems like as long as you had a warrant to get the sheath or to seize the sheath from the crime scene, of course you're going to send that thing off to the lab and swab it and see if there's anything on there that could lead you to a suspect. It's a major piece of evidence. So I thought that was a pretty interesting case she was trying to make, especially because, if it is indeed Bryan Kohberger's knife sheath and he leaves it at the crime scene because he screws up in the commission of a crime, oh, well, you screwed up. You can't just say, oh, well, I mean, he's saying it's not his sheath anyway. So how can you try to say you needed a warrant to test the DNA?
You can't, which is why Judge Hippler got it right. You got to understand something. He disclaimed all possessory and ownership interest in that sheath, if assuming it was him who.
No, he didn't. I'm saying someone in the chat is saying that Steve Concalves said on Ashley Banfield that he found Bryan Kohberger's kill kit. I'm saying that there's no way that Steve Concalves said that he found Bryan Kohberger's kill kit. In my opinion, that would be where did he find it? He just found it in the yard one day. I mean, that'd be
Left
so
it there.
weird.
It would be one thing if he was saying, yeah, that's my knife sheath. What are you doing with it? You shouldn't have.
No, I think people are people are hearing what they want to hear. I think what he said was, I bet Bryan Kohberger has a kill kit, or I bet Bryan Kohberger used a kill kit. And then creators take that, right? I don't know yet. I don't know what they said. We're going to go back and listen. But creators will take that and they will twist those words and they'll say that, oh no, Steve Goncalves said that he found Bryan Kohberger's kill kit. Do you see where you have to really listen? You got to listen. Like people, they don't listen to the words or something. Like sometimes I have to listen to things 3 or 4 times sometimes, like interviews, because I won't retain it.
Have it. Well, then there's an argument.
Or I'll hear something that and I'm like, did I hear that right? And I'll go back and I have to listen to it again, like a couple times.
To be made that maybe they do need a search warrant, but he's not claiming any interest in it. So what does the law say? The law says it's deemed abandoned. It's deemed disclaimed. And if that's the case, the police can collect it, test it, and do whatever they want with it and book it into evidence. And that's what they did. He just doesn't like the fact that he got sloppy at that crime scene and left it there. But he gave up any Fourth Amendment interest in it by leaving it there.
It's an interesting thing. And then the whole argument about the trash at the parents' house, too. I thought that was interesting because that to me seems like a well-settled thing. Even if there's a local ordinance that says only the trash company can pick up the trash. Like once you put your stuff in the trash and you set it out at the curb or it's in your trash can, even on your driveway or whatever, I always thought that was fair game, and the judge felt the same.
Yeah, no, the judge was absolutely correct.
Like
Mere violation of a local ordinance does not mean that it violates the Constitution. They're separate bodies of law. It might mean that the homeowner, for example, won't get cited by the city if they don't follow local ordinances, or that they forfeit their garbage pickup a certain number of days a month, that kind of thing. But to say that as a result of this, that you can impute a violation of a local ordinance regarding trash pickup to law enforcement and trying to work up a homicide, it's actually laughable. So the court found no, even a violation of that local ordinance does not violate the Fourth Amendment to the Constitution.
Yeah, they're definitely pulling on every thread, though. They're trying to get creative here. One thing I want to move on to now is this whole argument about the Google warrants, the Amazon warrants, Apple, all of these warrants. And there was an interesting bit of information that the judge included in his ruling. And it seems to me that, and I think there's been mention of Bryan Kohberger having somewhere in the neighborhood of 9 email addresses or something like that. And one of these email addresses that the cops uncovered is called username, but it's not spelled that way. It's spelled with a Y, username@gmail.com. And it showed that a login had occurred on that account at 4:49 a.m. on November 13th, 2022, soon after the homicides occurred, through what was likely a VPN server. And the detective stated his request for the warrant was to establish Bryan Kohberger's previous contacts, locations, correspondences, purchases, and any other information which could aid the investigation into the homicides of the 4 victims. Aside from the argument about them wanting to suppress this, which was denied, wow, pretty interesting that Bryan Kohberger, right after the cops are saying this murder occurred, these homicides occurred, 4:49 a.m., right after his phone reconnects to the network or whatever, he says he's out at some park, according to some other documents, doing whatever he's doing at a park, connects through a VPN possibly to some weird recovery email. Is that a really bad fact for the defense? Is that maybe a reason why they wanted to suppress this information?
Yeah, anytime the defense files a motion to suppress or to traverse a warrant, it means they're trying to chip away at the evidence against the client. I mean, obviously, that would be the only reason why you would do it. Otherwise, what's the point? It's, you don't just file motions just so you can rack up billable hours and get paid by the court. There has to be.
I would beg to differ if you're getting paid $200 an hour.
Some legal benefit.
Ooh, Jay Logston ain't gonna get that $180 an hour no more. I wonder how he feels about that.
for your client. And in that particular case, the timeline kind of sinks him where if at certain times he's doing certain entries, sending certain things, it could kind of poke holes in his precious alibi. And it could show some form of consciousness of guilt given the timing of when this stuff was entered and sent. So yes, that's precisely why Ms. Taylor filed that motion. And unfortunately, it lacked merit.
The defense was arguing that basically these warrants weren't specific enough, the affidavits weren't specific enough, and that the Apple, Amazon, Google, all of these warrants violated his rights and his rights to privacy. The judge says otherwise.
Yeah. Look, the law does not require certainty when you prepare an affidavit of probable cause. The standard is probable cause, not absolute certainty, not definitiveness. As long as under the totality of the circumstances, you are looking for evidence that probably points to the commission of a crime and probably points to him being the defendant, being the perpetrator, under the totality of the circumstances, the court can deny that motion because in its totality, everything corroborates each piece that was part of that puzzle. And the court found that there was no flagrant misconduct, no intentional knowing lies, or any type of outrageous government conduct. Everything was based on approximations and something rooted in probability rather than certainty. And that's enough constitutionally.
I want to get now to the Franks hearing and him denying the request for the Franks hearing. He found that these law enforcement officers, in his estimation, he found them credible. He didn't feel like they were making reckless or intentional misstatements. And he didn't feel really, this is really important because a lot of people were like, oh my God, after the last hearing, and Ann Taylor was saying that, DM, the surviving roommate, was saying she couldn't tell if she was, what she saw was a dream, and she was kind of doubting herself, and she was intoxicated that night. The judge is coming out and saying, look, her statements, her 3 interviews were remarkably consistent. And she's saying these things, but they didn't need to provide that as exculpatory information in an affidavit. They basically were honest in these affidavits, according to what he believes. So he's saying, look, just because she couldn't identify him in a lineup or through his mugshot because he was wearing a mask, he's like, of course she couldn't identify him. He was wearing a mask, the guy that she saw. That's of no consequence. So your thoughts on him denying the request for a Franks hearing, because the defense really kind of went after DM and said, look, they should have said, she's saying she didn't know if this was a dream or not. But he's saying her interviews were consistent with law enforcement, all of those interviews.
Well, there are 2 important legal points. Number 1, whatever inconsistent statement she gave or whatever fuzziness there may have been in her recollections are great fodder for cross-examination should she testify at trial. And you can impeach her credibility with her drunkenness at the time, or maybe she was hung over after the fact, that kind of thing. But most important, and constitutionally, that if you sever all the statements that law enforcement relayed in the affidavit of probable cause about what, if anything, she relayed, there was still enough in the affidavit to show probable cause. So, and the court found that even assuming there were inconsistencies or falsities, if you will, as to what she may have said, it didn't rise to the level of constitutional outrageousness to say that this was knowing and intentionally reckless. So the court found, no, you didn't meet your burden under the totality of the circumstances. There is ample probable cause.
And finally, they wanted to throw out, the arrest in Pennsylvania at his parents' house because they decided at the last minute to do kind of a no-knock warrant. They drove the Bearcat into the driveway that they were in, the armored vehicle. They kind of announced they were there, and then boom, they bash in the door, and they go in and they grab him out of a bedroom. And then they wanted to suppress any statements that he made, even though he had been Mirandized, because they were saying, oh, that's fruit of the poisonous tree because you rammed in his door when you didn't have to. Judge Hippler's saying, nah, I don't think so. This was fine. And they're saying, Judge Hippler's saying he's walking around the house. He's got a hoodie on at night, late at night. He may have realized he was being surveilled by law enforcement. His car is parked in his parents' garage, and he's going out there in the, late at night with a plastic baggie, and he's got the key fob, maybe unlocking it and locking the door. They think he's destroying evidence. And then he's walking around with, plastic gloves on. So Andy had a handgun in his bedroom. So there were all these things that kind of made them think, we got to just bust in there and get this guy.
Well, 2 points. Number one, the Constitution no longer requires suppression of evidence under the exclusionary rule if you fail to just as a courtesy knock and announce your presence. Remember, they had a search warrant or an arrest warrant. They went there already armed with the documents that they need to take him into custody, and merely knocking on the door is a courtesy. Constitutionally, they did away with that requirement for purposes of suppression, I think back in 2012 in a case called Hudson versus Michigan. But even assuming that the right to knock and announce survives, your remedy is purely civil, meaning you might have a civil rights lawsuit against the cops for, bulldozing their way through and damaging things and seizing things, that type of situation. But most important, what the court found is that even in that scenario, the police can dispense with knocking and announcing their presence in an exigent situation. So if you have an emergency type situation where, first of all, you're there because of a violent crime, not some petty offense like somebody passing bad checks or joyriding a car, but you're there on a 4-count homicide. That's number one. And number two, there's fear that this person could still be armed. And number three, that this person might try to escape. You can dispense with knocking and announcing your presence and just go in and take him in and seize whatever is in plain sight. And the court was not going to kick a 4-count murder just for failing to knock on the door, wait a few extra seconds in a situation where the police actually went and got a search and an arrest warrant signed by a magistrate based on probable cause. It just wasn't there, and suppression is no longer the remedy.
Yeah, it was some interesting reading, Philip. We learned a lot. Yeah. We learned a lot of new information, and I'm not sure that the judge's rulings were unexpected. I think some people thought, oh, maybe there's something there with the IGD arguments, but the judge said no way. So stay tuned. I mean, this did not go well for Bryan Kohberger. Oh. If you're Bryan Kohberger's lawyer, what is your next step? Because they've kind of said in the past, this is going to trial. What do? Do you explore any options? Like, all this stuff is coming in. Do you explore any options? Like, do you go to the prosecutor and say, hey, would you take the death penalty off the table if he just agrees to life without parole?
Precisely. You work up the mitigation now, because I think he really is sunk in the guilt phase. They have ample evidence to get a conviction. The real question now is, do the aggravators outweigh the mitigators? What can you show the prosecution by way of psych reports, accomplishments, the lack of a record, and your client's willingness to maybe plead out and take a deal for life without parole in exchange for taking what I call the wall off the table, the wall meaning the firing squad, or certainly the needle. Lethal injection. And that would be a tremendous victory in a case like this, because if history is any clue, an Idaho jury is not afraid to sentence people to death. And we saw this with Chad Daybell not too long ago. They had no problem sending him to death row. So he is now condemned, awaiting a death warrant. And it would not surprise me in the least if the same thing happened to Bryan Kohberger. So the question now is, what can we do to save his life, not to walk him? And that's what I would do. I would work up mitigation now to plead it out.
Yeah, it's 4 kids slaughtered in the middle of the night for no reason at all.
None.
No reason.
Just horrific. Philip Dubé, thank you so much.
Take care now.
Haley Gonsalves's family issued a statement after the judge's orders became public. It reads, "Praise the Lord. All the motions to suppress and Frank's motion have been denied. It's always a double-edged sword waiting. You want the right decisions to be made, but you also want them to be made quickly. We are thankful to the court for a timely decision and appreciate the work prosecution has put in thus far. In the big picture of life, justice is just moments away. Thanks again for all of your support and love for our family." And that's it for this episode of Crime Fix.
That's all they got. Okay. Let's watch that Ashley Banfield and see what they were talking about over there. Because I'm curious to know. Now, I'm assuming he said that, he thinks he probably had a kill kit. I'm going to disagree with that. I'm going to say he really probably didn't have like a kit. Other than maybe I think this was his first kill. So I don't think he had this. I think he had it planned out and everything, but I don't know if he'd have an actual kit. I think he just kind of went in there with his knife and his sheath. He forgot his sheath, for God's sakes. I do think that he had something to put his clothes in. I think that he was wearing those Dickie coveralls or overalls, and he put those into some sort of bag and then probably put the bag in his trunk. It was probably a sealed bag. To where nothing could get onto anything in his car. Shoes probably had coverings, or he took the shoes off. That could be a pretty simple thing to do. But
whose daughter, Kaylee Gonsalves, was one of the 4 students murdered at 1122 King Road, allegedly by Bryan Kohberger. Steve, it's good to have you tonight.
This won't go away.
Especially with this incredibly earth-shattering news in this case. I can just see it on your face. This is such welcome news to you.
Sorry, guys.
Yeah, this was a day that we've been looking forward to for almost 2.5 years. And
there we go.
It's kind of like the last Hail Mary that they were going for, to just throw it all out, put all the chips on the table and go for it. And we like the way that things turned out. We're going to go into the case with the same evidence that we started with. And that's amazing.
I just think when I say kill kit, I don't think he had another one in his car ready for the next kill. Do you know what I mean? Killers, they do. They have kill kits everywhere. They have them Israel Keys. His were buried out in the woods. He just knew where they were, I don't think he has those.
That's a great deal.
Yeah, I keep saying game, set, match, right? With that DNA evidence that ties what would have been a complete stranger right to the bed where your daughter was murdered. That is a hell of a bad fact for defense. Listen, the way it works is on their side of the ledger, Bryan Kohberger can cry into his defense attorney's shoulders and ask, what's next? What do we do?
Right.
What happens? On your side of the ledger, it's the prosecutors. Effectively, they're your lawyers. Do they talk to you? Do they get you through this? Do they help you with the patience factor as you wait all these months for these decisions?
The communication, it comes and goes. I try to assume that they're just super, super busy, but I'm an active person, so I wouldn't find my own lawyer. I found my own prosecutor, my own person who understands law to an extent that they do, even better than some of the people that are in that courtroom. So I feel like we're pretty much informed, and we're prepared for what's going to happen, and we're all working as one unit. And it's good to have days like this. It took a long time, but and people like Payne and Moyer, who literally were dragged through the mud, and people accuse those guys of lying or misrepresenting. It's a great day for them. These are men that dedicated their lives to our community, and today is a day for us to all embrace that everybody's seen them doing a good job, and everything that they did will be part of the case. And all those challenges were invalid.
You were referencing that you went and got your own lawyer, that Shannon Gray. We've spoken to him a lot. He seems very invested and certainly very caring when it comes to yours and your family's benefit here. And, it's like you still want to know what else, what still worries you? This is a great day. Obviously, this is the best day. But what still worries you ahead?
There's little pieces. If you read all through all the documentation, there's a lot of paperwork that came out today, a lot of details that weren't out. we look forward to that because there's details that we've had to hide, the things that we've had to keep to our chest. And the more that once they say it, then we can say it. You know, we can bring more details out. And we said a kill kit, you're going to read those documentations. You're going to find out that this individual left that house and people spotted, you know, these things that were going out with him. And we bring that up because people, please don't forget, this guy was not a part of our community. He was not a part of North Idaho. He's not even a citizen of Idaho. This person came here with a plan, premeditated, cold-blooded murder. And then he wanted to be a successful murderer, like a serial killer, somebody he studied. This is a sick individual that killed people sleeping in their beds. And there is no reason to have capital punishment if this isn't the case for it. So we're going to rely on all the people in the true crime community, all the people watching this, because it's going to get rough. We're going to have to put somebody all the way to the very ends of justice. But I think that's necessary. I feel like some of the reasons we have these mass shootings, school shootings and things, is because we don't do a good job of showing the very end of how this ends. And once kids see the full picture of what these disastrous behaviors are, maybe that puts a little bit in their head to slow down, think it through, talk to a friend, talk to a counselor, go to your school, communicate with somebody. Don't do this. Don't make one of these decisions where you take a bunch of people along with you.
We're just looking at the pictures of the people we should be talking about tonight. Your daughter, Kaylee, her best friend, Maddie, Xana in the far right there on the bottom right, and Ethan, her boyfriend. You know, maybe it's not coincidental, Steve, that all of this flurry of activity recently in the Idaho House overwhelmingly
I'm
passed
muted.
legislation that would make the
I was saying that the only documents that I haven't read, you guys, are the transcripts, and they came out today. This interview was a couple of days ago, so it wouldn't have been what's in the transcripts. So we'll read over the transcripts though tomorrow. We'll start on those tomorrow. It's going to take us a few lives probably to get through them.
the firing squad the first method of execution, not the backup method, not the choice, but the first method of execution, which I think would send shivers down the spine of Bryan Kohberger tonight, knowing that his case is so much harder to win. Do you follow the news of the firing squad and the plans for Idaho?
Oh, yes, he does.
I don't follow it. I help make it. I'm talking to some of these individuals in the state of Idaho. We're definitely being out there. If they need somebody to sit in front of a camera and take a little bit of time to help identify what, I hate to say a victim, but somebody going through this, and to rally support around a law. And you don't know it until you go through it, man. This is real, and it's ugly. And when somebody kills you while you're in your bed, you haven't done anything to deserve it. And I'll be that person. I'll be that person to stand in front of the camera and drum up some support. And yes, Bruce is the main guy behind the last Bill 37 here in Idaho. So yeah, I've reached out to him. I've spoken with him. I've spoken with even others before and after. And it doesn't even just end in Idaho. I mean, there's other things in the works where maybe some of these individuals don't even stay in the state. Maybe he can keep being a drifter, and we can drift him right on to El Salvador or one of these other locations where they can host these monsters, and they can be around the people that they look up to.
Steve, I'm happy for you and your family that you got this news today. You deserve good news. You've been waiting a long time. You've been patient. This is nothing anyone can imagine if they're not walking in your shoes. So thank you for joining me tonight.
Thank you.
And thank you. And keep me posted on your efforts. As you said, you're speaking to politicians and those who are making this change. Keep us posted on your efforts. Appreciate this.
Thank you. Thank you, ma'am.
Oh, blessed. Yeah, they are. Yep. They're all soft. They're all very soft. Trying to think if there's any that's not. No, they're all pretty soft. I have sensory, big sensory deals. And I'm trying to think like if any of them are itchy or anything, and they're not. No, I don't think so. Yeah, if there's a kid, there must be a knife, right? Maybe, yeah. Okay, thank you, Rolo. I'll look over it. Yeah, I'll look over those the documents that just came out, or the transcripts. I just didn't get a chance to even read through a page of them because I was all the way back here earlier trying to get ready for the live. I had my keyboard like literally on my lap, like back here. I was like, am I even doing a live tonight? It was like that. It was literally like that because Vincent was trying to put this light up, which it's huge, but it didn't give off enough light. Like we thought we'd only need one light. It's like this big. My other one's only like this big. Like, so we had to turn another light on over here. And then, yeah, we're remodeling the whole studio. So it's been crazy, 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 crazy. Before I let you guys go, let's see something really quick. Also, if you guys are wondering why I didn't go live about Sebastian and the new video that's out, the Ellie has come forward and said that it wasn't of any investigative value. So that's kind of why I didn't run to the computer and scream from the rooftops about it. So if you guys were wondering. So, yeah. The transcripts are out. I just didn't I didn't read them. No, there are 175 pages of transcripts. So I'm trying to get somebody to read them with me. That way it's like less boring in a way, like I was going to try to see if maybe another creator wanted to read them with me. If not, I'll read them by myself. But, I'm going to have to say like, this is Anne talking and this is this person talking, when it's like, if you had another extra person, it might help. If not, maybe I'll get one of you guys to come up here and help me with it. But we'll be covering those documents. We're going to be covering the new they had another podcast come out where they just sit there and they talk about the evidence in the case and all of that. That just came out tonight, so we can go over that tomorrow as well. And I have so many tabs open for Idaho. I had to literally put these onto a different tab tonight, like the stuff that we were going to go over tonight, because I was like, this is just too much. I mean, it's craziness. Plus I'm looking at my cousin's case now too, and I will be coming live with that whenever I get all the information that I need from that. And, I look at it, I cry it out, I look at it again, I get angry, then I bring it after I have a minute to process it as myself. Cause I haven't done that. Move my trash can. It's too far back. So, thank you guys for being with me tonight. I appreciate you so much. Tonight we did learn, that they are going to be replacing Jay Logston with Becca Barlow, which was an expert witness for them at one point, and she's now going to be co-counsel. I wonder if she gets $180 an hour. I wonder if they're going to pay her the same. I don't know. Hey, Jeff. KJ, I did see. Okay, KJ, I did see in the beginning when she was getting mad about something because she was like, I'm sorry, I didn't print out the 1,000 pages to bring as an extra copy. And he's like, the judge is like, well, you got to bring your your extra copy. You got to bring a copy for me. I was just like, oh, dang, Yeah, I hope you're doing good, Jeff. I haven't seen you in a while. Well, it's only been a couple days, I feel like. Well, maybe more than that, actually. It's been about a week or so. Did hubby fall asleep there, Mary Beth? Get the credit card, Mary Beth. If he's sleeping. I'm just kidding. Just kidding. So yeah, we'll go through those documents starting tomorrow too. It's going to be a lot, but it'll be fun. It'll be fun. We haven't read a lot in a while, I feel like. Oh, and I don't hey Bullets and Bling, do you want me to actually I'm going to put the if you guys want to go look tonight, because I think that a lot of the stuff that we're going to be hearing it's not going to be like 100% true or 100% correct. So what I'm going to do is I'm going to put if you follow this link, it'll take you right to the website. I'm actually going to do you one more. I'm going to take you to the website. So when you pop up, it's going to look like this. And this is the Idaho Judicial Cases. And if you just scroll down, you'll see Bryan C. Kohberger from the affidavit. If you just keep scrolling, all of his documents that we've read every single one of these, except for the last stack that came out. But all the way at the bottom, you just keep on going. Oh, there he is. Okay. Transcript. Redacted hearing held January 23rd, 2025. Now, the defense and the prosecution has both had 14 days to go through here and redact things that they didn't want put out. I think some of those things, if those were true, they would wanted those redacted. But that's just me. Yeah. And I think that's all I really have for you guys for tonight. I was thinking 818 referred to the I was thinking the alcohol, but then I was thinking, isn't 818 like an area code? But isn't that like Vanilla Ice? Doesn't it say 818? Is it California? Oh, look at that. San Fernando Valley. Bam. I knew it. I knew it. The transcripts are a good read. Okay. Well, I'm not reading them, then I'm going to read them with you guys. I'll always cover this case, Miss Robat. Yeah, always will, because we've been covering it since it started. We try to do that. We try to, Oh, maybe it is A1A. I always thought it was 818. Beachfront Avenue. That's what I thought, or Beach something Avenue. Right? Now I'm going to have to go back and look. My brother had it was before kind of my time. It was like my brother's time. So I may have the words wrong. Now I'm going to go out there and ask Vincent. Oh. See, I didn't know. I thought A. At first I thought it was alcohol. The brown and white sweater would look good with the black pants that you have. If you're talking about that sweater that's like with all the different, like the colors, like it's like boxed. And the back of it, I think I should have a picture of the back, but it has a bow. Oh, A1A runs along the water. See, on the east coast of Florida. Oh, okay. I'm about to say, because I've been up the coast of California. Been all up the coast. Vincent took me once. It was really nice. Actually, we've went a couple times. It's really nice. And hey, Wandering Orphan. And we so yeah, you talking about okay, beach. So I wasn't wrong. I just was wrong about the area. I gotcha. Takes me back. My brother had that cassette tape. Actually, I think he had the CD too. I think it was like the first CD he ever got. My first CD was Backstreet. No, Blackstreet. Not Backstreet Boys, Blackstreet. The R&B band. Yeah, I must have. I don't know. I love their music. I'd be dancing to it all the time. I would dance to it right now. Both coasts are lovely. I've actually been all the way to the southern tip of like Florida. Me and Vincent went there. Look at us doing things. We haven't done anything in a while though. We need to. Oh, he's from Miami. That's why. Okay. I know I need to order some more stuff. I've got the tabs up on my other page. I was writing down like all of they're all the same brand, but they're different. Okay. So it's weird. My store's weird. Well, not my store, it's just this company's weird. There's a company that I love to go through, like to get clothes, and they are the same brand, like Lovetree, mine, and then they have like 2 other brands that are like in that same thing. And like they're all the same brand though, but they're just named differently. And I'm like, y'all are the same brand. It's like, why you do that? The Foreigner 4 cassette tape. My dad went to a Foreigner concert, I believe. He loved Foreigner. I don't know if he went to their concert, but he did go to a few concerts. But I know he liked Foreigner. My dad did. Doodlebug, you changed your picture. I'm like, wait a minute. I need to go to the Florida Keys. Ace of Base. Oh, they had one good song. I'm just kidding. They had a couple good ones. I want to go to Crime Con. I told Vincent. Sugar Ray. Yeah, I liked Sugar Ray back in the day. Who else did I listen to? Oh, I listened to all kinds. Now if you guys heard my Pandora, you would laugh. It'll go from like a country song to like a rap song to like a 70s, rock song. And I'm here for it. It's like, I'm here for it. Every day that I work out, I'm just like, let's see what we're going to listen to today. I should record one time or do like a live or something with you guys when I'm like working out one day. But then I feel like, I don't know, y'all would be like, well, look at her workout. Like when I'm on my walking pad, like, cause I'm on my walking pad, I'm on there for like an hour and I'm just like chilling, just walking. I could be like talking to you guys. Could be talking to you. I do still use Pandora. I have given them $12.99 of my hard-earned dollars or whatever it is for Pandora Premium, like the one above the first one, for like 20 years now. I don't use the other one. What's Spotify? I've never even used Spotify before. What's Gambler? Oh, the Gambler. Oh, it's like, well, I thought when I first saw Gambler, I was like, wait. Kenny Rogers? Oh, man. Wandering Orphan. Aerosmith was a good one. Really? Oh man, I like Pandora. I love Tom Petty. I'm so sad that I didn't get to see him in concert. My dad loved Tom Petty. I know too many Tom Petty songs. I don't think you can know too many. But I will tell you one music band that I could never live without, but I could live without. Like one of those kind of like I shouldn't have I didn't need them in my life. But now that their songs are in my head, they live rent free. And every time I hear them, I always think of my dad. Is the band Chicago. I know every word of every song made by that ever played by Chicago. My uncle loved them. My dad loved them because my uncle loved them. And now the music nowadays is just, I don't even know. You love Chicago? Yeah, my dad loves Chicago. But every time I hear their songs, my dad would always play like Chicago when my mom was mad at him. He'd always play Chicago because it was always like love songs, and like just it would be like I would be like, oh my gosh, because I was like a teenager and I would hear him out there singing Chicago. Are they still doing it? Are they still playing? If they're playing, I would love to see Chicago the band play. I'd probably fall out of my chair to hear them. Oh no, Tennessee Gal. Was that yesterday? Did we talk about her last night? No, we didn't. I don't see anything. Oh, wow. Trending even. There's surveillance video of Sebastian. I don't know. Maybe it's just me. I can't like get excited about things because it's just like, I don't know. Everything always ends up being like not true. And yeah, we'll see. We will see. I mean, if it's him, what does it mean? Nothing. Like, right? I mean, nothing's changed. It's not like he walks in somebody's house. Like, and you can't see that far. And I swear to you all, if you all go and you listen to any channels doing any overlays of that video, I'm gonna go into all them chats and I'm gonna find you all and I'm gonna like lasso y'all up and bring you back over to, reality. Because I think Mob Crew is still messing with the lights video. So he'll be messing with that to the day, the dawn of, we'll all be gone. We'll all be dead and gone and he'll still be messing with that video. But thank you guys for being here tonight. I appreciate you guys so much. If you guys don't mind hitting the like button, hitting the subscribe button, hopefully you guys are going to have a great weekend. Hopefully you have something awesome planned. I've been staring at these drapes behind me and they're so wrinkled. Vincent was like, "You're not going to steam those?" I'm like, "Of course I am." Like they're so bad. I'm going to have to steam them like tomorrow. But hopefully you have a better, Saturday plan than steaming curtains. But if you guys have something fun planned, let me know what you guys are going to be doing. And I will see you guys all tomorrow. I think we'll do a day live, whether it's like a members only or something. We'll do something or maybe on the second channel, but it'll be either tomorrow or Sunday. We'll definitely get something in extra for you. So thank you guys for being here. Thank you guys for gifting out memberships tonight. I appreciate that. Mary Beth, you gifted 10, and then KCG, she gifted out a membership as well. And then I gifted out 5. Maybe we can give some out on the other channel tomorrow. And maybe we'll give some more out on this channel to get our memberships up to 500 there. Mary Beth's she's on a mission. So thank you guys for being here and I'll see you guys all tomorrow. Good night, guys. Bye.
Just like the street lights lit this town, like a fire in a blaze, gotta burn it down. Can't be afraid to leave this out. We got this far, don't know how.